Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, a few days ago, we did this video right here, and it was about the huge news that came out of the United States Supreme Court that they had accepted for next year's term review of United States v. Rahimi, a huge case that had to do with forfeiting of firearm rights based upon indictments and allegations. Now, we also talked about what a really sticky and tricky case it's going to be for everybody involved. So I would encourage you to geek out on that video to get more information about that. But in taking a look at the comments on that video, many of you asked very intelligent questions, and it actually got me geeking out even a little bit more about this issue. And that's why we're using this as kind of a representative of what's happening, because we really do believe that United States v. Rahimi is really just the tip of the iceberg. We think that this case actually has the ability to have very far-reaching implications, and we're going to explain how in just a moment. So today, let's spend a couple of minutes and get you all educated on how the Supreme Court's next gun case is going to be huge. Okay, so what we're talking about again today is the accepting for certiorari, the accepting for review by the United States Supreme Court in the United States v. Rahimi. As we know, Mr. Rahimi, not particularly a nice gentleman from the allegations, was indicted for a violation of 18 U.S.C. Section 922 G8. What is 18 U.S.C. Section 922 G8? That is a federal statute which makes it unlawful for a person to possess a firearm in the following situation. It shall be unlawful for any person, 8, who is subject to a court order that A, was issued after a hearing of which such person received actual notice and at which such person had an opportunity to participate, B, restrains such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child, and C, includes a finding that such a person represents a credible threat to the physical safety of such intimate partner or child, or by its terms explicitly prohibits the use, attempted use, or threatened use of physical force against such intimate partner or child that would reasonably be expected to cause bodily injury. Now, that is a big, gigantic word salad for saying that it is unlawful for you to possess a firearm if there is a court order restricting you from possessing a firearm due to an allegation of domestic violence or other types of threats or violence against another person or intimate partner. There is no finding of guilt. You have not been convicted by a jury of your peers. You have not been found guilty beyond a reasonable doubt. You have been charged with a crime. A judge has made a finding of probable cause, which is a preponderance of evidence standard, okay? Viewing the evidence in the light most favorable to the charging party, by the way, all right? And because of those allegations, as long as you've had an opportunity to be heard, does that order prohibit a person from being in possession of a firearm? That's the issue here, okay? Is it constitutionally permissible to strip an individual of their Second Amendment rights under these circumstances? Now, unfortunately, we've also said that bad facts make for bad law. Some of you corrected and said hard cases make for bad law, and it doesn't really matter because this is a case that is full of crappy facts, and we do believe that the Supreme Court is, in fact, going to struggle with this issue. But here's the thing that I want all of you to understand for purposes of this video. There's a lot more at stake when we take a look at what this opinion is all about, because even though the issue will be framed as to what is the constitutionality of 18 United States Code Section 922 G8, which is what Rahimi was charged under here, that is only the tip of the iceberg. And so when we begin to take a look at what lies under the water's surface here, and we start analyzing what other instances are there in American jurisprudence in which an individual can be stripped of their otherwise inalienable Second Amendment right of self-preservation because of a mere allegation, which maybe was at best found by preponderance of evidence, a civil standard, not proof beyond reasonable doubt, not conviction by a jury of your peers or anything like that, but mere allegations, some type of evidence that would then strip a person of their inalienable rights. Okay, well, here's the deal. For example, if we take a look in the very same statute, right underneath the water surface, there's 18 United States Code, Section 922, Section D1. That makes it a crime to be in possession of a firearm if you have been indicted, charged with an offense in which you could potentially face up to a year or more in jail. Now, you can assume there are all sorts of offenses, including a bunch of white-collar crimes, embezzlement and things like that, where, you know, depending on the amount of money that's being taken, you could be stripped of your Second Amendment rights merely on a finding of probable cause by a judge, okay? Does the Rahimi case affect that? It arguably does. Let's take a look at 18 United States Code Section 922 D3. What is that? Well, that makes it unlawful to possess a firearm if you are an addict or an unlawful user of controlled substances as defined by federal law. Now, we've been talking about that issue for other reasons recently, but again, it doesn't say that you've been convicted of a crime which establishes that you are an unlawful user or addict of a controlled substance. No, this says if there is an allegation or a belief that you are a user of controlled substances, you are barred from your right of self-preservation. But then I want you to think about this. Where else in American law could a person be stripped of their Second Amendment rights without even having a criminal allegation against them, and therefore there would be no proof beyond a reasonable doubt? It would be based solely on some allegation by some other citizen or law enforcement officer against that individual. Oh, guess what? That's exactly how red flag laws work, okay? Red flag laws are laws that are designed to strip individuals of their Second Amendment rights based on allegations that they pose a threat to themselves or others by having access to firearms. Now, I'm not saying that every one of those allegations in a red flag hearing are bogus. Some of them happen to be very, very accurate and concise allegations. But there have been many, many instances in which an individual was falsely accused. But here's the thing. Even if the allegations are absolutely 100% accurate, and even if the stripping of the firearm rights is appropriate under a safety standard, is it constitutionally permissible, procedurally speaking, for a person to be stripped of their rights without notice and a meaningful opportunity to be heard? Because you see, for many red flag laws, there is a temporary order that will be issued against that individual after an ex parte hearing, which is a fancy way of after hearing only from one side. So yeah, as we get deeper and deeper underneath the water's surface, we begin to see that red flag laws are also potentially going to be significantly affected by the holdings of United States v. Rahimi. And when we get deeper under the water surface, we also see that there are all sorts of other civil orders, civil anti-harassment orders, civil protection orders, civil no contact orders. Many of these involve neighborhood pissing contests where they're just not a big enough boy or girl to settle their own disputes, and they end up in court having the pissing contest in there. And then, of course, all sorts of allegations are made. The lack of emotional regulation plays out in the courtroom much like it plays out in the neighborhood, and there is oftentimes allegations and orders which strip individuals of their Second Amendment rights based upon what their neighbor has alleged about them. Now, all of these ideas actually came from my viewers who are asking questions related to this particular case, and that's what got us down this road. Like, boy, you know, this Rahimi case, we thought it was going to be huge, but now upon further review, this has an opportunity to be an enormous case that could have absolutely earth-shattering and lifelong consequences for all of our Second Amendment rights. The case, once again, is United States v. Rahimi. It's going to be argued next year. We're going to keep you posted about it. This is going to be an important case. This case could be every bit as important as last summer's Bruin holding. If you have any other questions about this or anything else related to what's left of your Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.